because sooner or later we're going to have a special law on crypto assets, including on stablecoin. In the meantime, Taiwan is also experimenting a lot of securities token or application to the securities. So parallel tracks, there are several parallel tracks moving on. And I'm fortunate to be part of many things here, so including so basically I'm in charge of drafting the act and the associated regulation as well. So that's why I'm a little bit hesitant when it comes to like uploading to the YouTube, because I believe we're going to talk about something that is somehow inside the government, a lot of thinking, a lot of considerations, which is not to the public yet. So let's see. Okay. Let's see.
Meng Meng, he has additional question. Please join, show your face as well. My first question is actually based on your paper. You suggested that jurors should have a right their reasons on crypto disputes. But do you really think people will do that for small disputes, like a few $100s? Wouldn't it be more realistic for people who just guess what most other things like crowdsourced voting does now? And I believe your idea is more about the large-scale dispute, but in a small-scale dispute, I think the current system might be the very innovative. I've never thought of this kind of system, voting and majority decided the result of the dispute. Wow, this is a great idea.
Yeah, but I think in my paper, I also mentioned that probably in the footnote. So this is not new to the crypto world. Actually, eBay had that similar system, crowdsourced arbitration system, I think 15 or 20 years ago. So this is actually something that already been thought of during the online dispute resolution, the ODR era. And of course, crypto people bring this idea into the crypto world, which is fair because, as you can imagine, it works better for small-scale disputes. I think you're right. Obviously, for small-scale disputes, people have less interest in retaining even just one single arbitrator to resolve the disputes. It costs too much. And for the arbitration institutions, they probably have no interest in this business as well because these are consumer disputes, which is, again, too small for them. So I guess the so-called crowdsourced dispute resolution is a way out, trying to somehow allocate the cost of dispute resolution to the public so as to maintain a robust system. I think this is fair. I'm not trying to say that this is the only way to resolve the crypto disputes or online disputes, but this could be a fair way. The remaining question addressed in my paper is simply whether the dispute resolution result would be enforced in the court. Because you can happily resolve your disputes in the online world, in the crypto world, which is nice, which is what we expect. No need to go to the physical court anymore. But for some cases, there might be a need. So for some cases, people might disagree with the crowdsourced dispute resolution result and want to overthrow that and do not want to obey that. And in that case, you need some enforcement. So that's the very purpose of that paper. So you're probably right. That is more about a large-scale dispute because, well, in our presumption, only those large-scale disputes would incur some kind of possibility to have a physical court to enforce the dispute, right? Because for small-scale disputes, even though some people try not to follow the crowdsourced dispute resolution result, they probably won't have enough incentive or motivation to go to the physical court to address the issue again. So you're right that in fact or in practice, it probably applies more to the large-scale disputes. That's something implicit in the paper, which I do not necessarily want to address that because that's a logical inference, right? Who knows, right? Some small-scale dispute might want to go to the court for whatever reasons. So we don't really need to classify this as exclusive to large-scale dispute. The discussion there could apply both to a large-scale and small-scale. But in terms of opportunities, perhaps large-scale disputes have more chance to apply the finding of this paper. So you're right. Yeah.
you mentioned that the enforcement part, and while researching what's current at who had some innovative idea to resolve those enforcement as well, and I found that Kleros bridge, Kleros bridge, and they provide the mediation in blockchain dispute, mediator who divide the issue on that dispute and provide their view, and then the jurors vote based on that mediator's view, and they insist that's enforceable because of Singapore conventions. And as soon as I read that, wow, this is great. It can resolve the idea of low cost, fast, and plus enforcement. And how do you see Catalyst a model to resolve the blockchain disputes? I'm not sure whether it had been tested on court, but they insist it's enforceable based on the Singapore Convention about the mediation.
Yeah, I think there is all the chance because my paper is more about arbitration, less about mediation. So my paper talks more about whether the crowdsourced dispute resolution constitutes an arbitration which can be enforced under the New York Convention. And my finding is that, well, not 100% there. There could be some improvements that could be done to make the crowdsourced dispute resolution as an arbitration, but probably they are not yet there yet. But that is a separate issue to mediation, right? There is all the chance for this crowdsourced dispute resolution to be considered as a mediation under the Singapore Convention. There is the chance. I didn't do that analysis in the paper because I'm less familiar with it. Maybe just to be frank, I haven't done that study yet. So no conclusion yet. But I believe there is all the chance for the dispute resolution result to be considered as a mediation qualified under the Singapore Convention and then receive the enforcement, the effect. What I want to add more a little bit on that is actually there are more technological ways to enforce the dispute resolution results. So for those crowdsourced dispute resolution, they typically hold a smart contract and code the dispute resolution result into the smart contract so as to make sure that once the dispute resolution is reached, the smart contract will automatically execute the dispute resolution result. So maybe there is a need for an oracle to connect the smart contract of the disputes with the decision of the dispute resolution, but that is totally doable. I believe in some crowdsourced dispute resolution, they have already done that so as to ensure the enforcement of the dispute resolution result. So to be frank, when I wrote the paper, what I thought is the reverse. What I thought is when the dispute resolution is made, it will be automatically enforced. So enforcement is less an issue. The real issue is the one being enforced do not want to follow the dispute resolution. And now they are forced, well, because of the smart contract, they are automatically enforced. And now they want to take back what they are being enforced. That means they do not want to follow, they do not consider the dispute resolution is binding to them. They want to have consider that as an appeal. They want to overflow. They do not want to follow the dispute resolution result. And now they go to the physical court to ask the court to decide on the dispute again, arguing that the dispute resolution is not binding to the court. So the court needs to do the examination all again on a de novo basis. That's what I thought of. So that's the scenario what I thought of when we talk about whether the physical court should follow, should be bound by the crowdsourced dispute resolution. That was what I thought of. But I think your scenario is a little bit different in the sense that you don't really use the smart contract to execute the dispute resolution result. So you need to go to probably some physical court to enforce the so-called mediation result and then arguing that this is a mediation. That's a different scenario. I believe that for those crowdsourced dispute resolution platform, they could even consider the way that I mentioned to execute the dispute resolution whatsoever, and then see whether people want to go to the court to overthrow the dispute resolution. So just to add on that aspect, I think in the crypto world, they like this smart contract execution, automatic execution, without the need to go to the court whatsoever.
Thanks for the kind explanation. And as you know, there is a lot of criticism on the international arbitration because it's lengthy, costly, and sometimes people did not realize how expensive they are. Do you think is it possible to minimize the cost and time consuming by these crowd-world blockchain disputes?
Yes, I do think so, because the international arbitration you just mentioned is more on the institutional basis. And you're especially talking about those big arbitration institutions, international arbitration institutions. They are costly, to be sure. They're not costly, they are pricey. That's all for sure. But when we talk about crowdsourced, or when we talk about blockchain arbitration, or when we talk about crowdsourced arbitration, or when we talk about crypto arbitration, it doesn't really need to be done in that way. It doesn't really need to go to those big international arbitration institutions. To be fair, those arbitration institutions might not be that interested as well. Well, to be sure, I believe ICC is interested. I believe more and more international arbitration institutions are interested in the crypto disputes. But for the dispute parties, they do not necessarily need to resolve their disputes in those globally well-known international arbitration institutions. There are all the other different ways, even considered an ad hoc arbitration system. So that could significantly reduce the cost. That's for sure. So if you're right that the crypto is the future and crypto disputes will become one mainstream disputes in the future, then I would say that for those smaller arbitration institution or the ADR mechanism to consider this market, right? There is a possibility for this boutique arbitration institution to find a way out among this somehow monopolized international arbitration market, right? So there could be a chance. There could be more competition in the arbitration market or mediation market globally. So yeah, there is always this chance, I believe. Yeah, because now this market is not there yet. Everybody has the chance to have the first mover advantage or maybe the latecomer advantage, who knows? So yeah, there's all the opportunities.
Wow, that's great because in maritime area, the ad hoc arbitration is very common, and then they do not follow the institution like SIAC, ICC, and HIAC, and they work fast and they cost less. There's no administrative fees, and it's very in line with this crypto world blockchain, or as you mentioned, crowdsourced arbitration word. And the audience may not be quite used to this kind of arbitration. So can you elaborate more about that?
Yep. So it goes to the very definition of arbitration. So although we use these words all the times, actually there is not a very authoritative definition for arbitration. That's what I studied when I wrote the paper. I realized that, wow, there is actually no definition, official definition, or a well-accepted definition for arbitration, not domestically speaking or internationally speaking. Many countries' arbitration laws actually do not have a definition for arbitration. So it really goes to what we define arbitration. The traditional understanding of this term is simply to have a third party to resolve the dispute for the disputed parties. And the disputed parties will have to follow the decision of this third party. That is the very simple definition of arbitration. So if we follow that definition, it doesn't really have to be a professionalized arbitration institution to serve as that third party in deciding the dispute. It could be anyone. It could be anyone, maybe even not the most professional ones, but that could be someone that both parties agree to have him or her to resolve, to decide the dispute for the parties. So ad hoc could work in the sense that it doesn't have to be a standing institution to serve as this arbitrator and doing that as a business. It could be anyone who serve as an arbitrator, on maybe not on a random basis, but not on a business basis. That's the ad hoc arbitration. And that's something that arbitration laws also honor. But that's in terms of law, right? In terms of practice, people still want to rely more on those professional institutions. That's inevitable. That's pretty in line with the human beings. So that's why when we talk about arbitration, we often talk about those arbitration institutions. But when it goes back to the laws, it doesn't really have to be that. The arbitrator does not necessarily have to be appointed throughout the whole institutional system. It could be simply appointed by the parties on a ad hoc basis, on a one-time basis. So that's ad hoc arbitration. It could work in the crypto world, right? It could work in any disputes, to be honest. Any disputes need not necessarily go through the institutional arbitration process to resolve the dispute in the form of arbitration. It could be ad hoc arbitration. It's just personal preference. It's just the preference of the dispute parties. So maybe in the crypto world, people prefer the ad hoc arbitration. Maybe not. We don't know, right? We need to see how the market evolves. But I believe that the ad hoc arbitration still has its role there. And let's see whether it could evolve into it could be rejuvenized, maybe in the crypto world. Let's see.
Wow, that's great. It seems like that now the new opportunities for dispute resolution is just opening, and there are a lot of chances for young lawyers because old generation is reluctant to accept the blockchain coin, especially Asian culture is very conservative and think this kind of thing as a kind of gambling. But the young generation is looking for new market for legal services, and either arbitration or mediation in this blockchain industry and crypto industry, this is new market for them.
Right, but I do want to add two things. So, of course, we talk about the opportunities, but to be balanced, we also need to talk about some risks. So these ODR, these ADR system, these blockchain arbitration system or crowdsourced arbitration system needs to really work. Well, if we want this system to work, it really needs to collaborate with the government, with the country, with the official system, the public sector. That's what I try to emphasize in my paper as well. It's fine for crypto people to stay outside of the public sector, do whatever they want. That's one thing. But if you really want to evolve and become a formal institution in the country, you still need to collaborate with the public sector. For example, if you want your dispute resolution result to be enforced by the court, then you need to win the recognition from the court, right? And that's what the public perception about this thing kicks in, right? So public perception still matters because it could affect how courts perceive this dispute resolution mechanism and affects whether the court want to enforce or consider the dispute resolution as a binding arbitration. So that's maybe not the risk, but that's the aspect that I do want to emphasize. It's not the case that the crypto world is always out of the public regime, out of the public sector, and can do whatever they want without any assistance from the public sector. That's not 100% true. So that's the first thing I do want to add on. The second thing I want to add on is that once the blockchain arbitration or blockchain dispute resolution is recognized by the court system, by the public sector, it could play a very significant supplementary role to the public sector's regulation of the crypto, right? One of the aspects related to the crypto asset regulation is the consumer protection. Well, I won't say that the old generation's perception of the crypto, this is a little bit like a gambling. It could be a gambling, or at least to be more neutral, people could invest in crypto asset for speculative reasons. People speculate on crypto asset. And there could be a room for criminals to fraud, to manipulate the market, causing all the market order concern, consumer protection concern, or investor protection concern. There is this concern. When all the countries enact crypto asset laws to regulate the crypto asset, one of the very motive is the investor protection or consumer protection. To that extent, the crypto or blockchain dispute resolution supplements the regulation to the extent that they facilitate the dispute resolution of the crypto asset related disputes so as to afford better protection for the investors or consumers. So I won't try to put the discussion here in a zero-sum game. I think this is a win-win collaboration. More and more countries want to regulate crypto asset to protect their investors. Crypto asset dispute resolution mechanism offers a more effective, efficient way to resolve the disputes arising from the crypto asset transaction. This is helpful for the regulation as well. So we don't really need to put like the crypto world and the public sector into two conflicting or opposite camp. They actually can work hand in hand together. That's what we're trying to promote as well. And one of the description would be you will inevitably see some crypto asset disputes in the crypto world. Traditional ways to resolve the disputes, like court, like traditional arbitration, might not work as efficient as those new emerging forms of dispute resolution. So for the regulator, if you want to control the disputes better, if you want to like protect your investors better, maybe consider this new form of dispute resolution. And on the other hand, we talk to the people who want to like launch this kind of dispute resolution platform. We talk to them, hey, if you want to be recognized by the courts so as to enhance your business opportunities, then you probably need to follow more or less some arbitration laws so as to classify yourself as an arbitration or mediation, whatever. So you can be part of the system. You don't really need to be outside of the legal system, outside of the mediation, arbitration system. Make some adjustments, make your dispute resolution more like an arbitration or mediation. Then you can serve the bigger market. So that's the two things I do want to add on. So I think this is a win-win. This is a supplementary as opposed to a war between the old and younger generation. Yeah.
Wow, thank you so much. You remind me of Jung-Soo Lee, who is a law professor of Seoul National University, top law commentators on this crypto world, coins, and digital asset markets. And he told me that in the court, it's still unclear whether court can enforce any crypto disputes because they do not understand what's this. And so enforcement of the court decision itself is unclear. Having said that, the only way which enables is a mutual agreement and negotiation mediation, because either arbitration or the court decision is unclear how to enforce that in the one jurisdiction, for instance, in Korea. So I believe Korea is not fast at the moment, and US is maybe the fastest country on this industry. Do you think the U.S. court may enforce the arbitration award of crypto world dispute?
So first of all, it's very interesting you mentioned Professor Lee because I just met him this February in Japan, and we talked a lot about the crypto asset regulation. So yeah, I also learned a lot from him, and we exchanged a lot of ideas what we perceive about the crypto assets. So it's very interesting. It's a very coincidence that you mentioned him, one of the very persons I just met this year. And second of all, I think, again, back to what I tried to highlight at the very beginning, I think a more robust crypto asset or crypto dispute resolution mechanism is trying not to use the court to enforce the crypto asset dispute resolution. So that's why I raised the technological solution, code the dispute resolution into your smart contract, and then automatically enforce the dispute resolution from the very beginning. I think that's the mainstream way for these blockchain dispute resolution to enforce their dispute resolution. In that way, you don't need a court to enforce the crypto. That's just too much hurdles there. You're totally right. So I think that's a more robust blockchain arbitration system should possess. So if that works, then you don't see much need for the court to enforce the dispute resolution. Instead, what the court needs to do or needs to decide whether to do is whether to review the dispute resolution on a de novo basis. Whether you respect that as a arbitration and then only withdraw that on very occasional basis, on very statutorily mentioned basis, or whether you consider the blockchain dispute resolution as nothing and you court want to review the case altogether on a de novo basis. I think that's the real tension that my paper talked about when I thought of the crowdsource-based blockchain dispute resolution. But you're right that once in a while, people might still need the court to resolve the disputes. For example, if you don't have an arbitration agreement, if you don't have a dispute resolution agreement, in that situation, you probably need a court to decide the case for you and then enforce the case for you. I think that's all doable. So once the court gets the idea, it's doable. I'm less familiar with the US case, but here in Taiwan, we have already done many cases. Enforcement cases involving the disputes of crypto asset, and courts do that. So, for example, I buy Bitcoin from you, and then you refuse to pay me the Bitcoin. You refuse to transfer the Bitcoin to me. I sue you. The court decided on my favor, and then I went to the court to enforce this winning decision against you. Then the court needs to enforce this Bitcoin to me, right? That's a very simple non-performance of a sales contract. Taiwanese courts handle those disputes. We had already had some disputes on that and some enforcement cases on that. So Taiwanese courts needed to step in to try to enforce that. And to be sure, this is not that different to the cases where I buy a car from you and you refuse to pay me to deliver the car to me. Courts enforce these kind of disputes on a pretty much similar basis, right? It doesn't really ask the court to identify your private key so as to use your private key to transfer the crypto to me. That's not the case. Just like if you owe me a car, it's not the case that the court has the obligation to find out that car, find out the car key, and then use that car key to drive the car to me. That's not how the court enforcement does, right? So there are ways for court to enforce a crypto dispute as well. Probably not that different with that to other movable property or other assets. So I'm not sure about, so to answer your question, I'm not that sure about the US cases, but if Taiwan can, I believe many courts can, right? So I believe that's doable for the courts. It's just the courts need to somehow a little bit understand how the crypto asset works, how the blockchain works a little bit, how the whole industry works. Finds out the right person to help the court to make the enforcement. For example, they probably need to treat the virtual asset service providers, like those crypto exchanges, a little bit similar to how they treat the bank, right? In some cases, when you owe me the money, the court can ask the bank to frozen my bank account so as to force me to pay the money. Similarly, they could also turn to my crypto asset exchange and ask the exchange to foreclose or frozen my asset there so as to force me to do something. So those are the things that are similar. I don't think that's technologically impracticable. I think it's more about the courts need to be more familiar with this new asset. And I have faith in the court, to be honest, because this is not the first time that courts face some new technological things, right? Courts evolve from all the time. So this is just another new challenge that they need to get involved. Yeah.
Thank you so much. Actually, Professor was my classmate in back 2001 in Korea when he passed the bar exam in 2000. We entered into Judicial Research and Training Center and spent 2 years as a public officer and just learning course for as a judge, lawyers, prosecutor, and we were at the same class and I was very close to him. And recently I had many communication about this digital assets where I'm very glad that you had a communication with him already. And secondly, and as you mentioned, if your idea is all the dispute resolution system is built in the smart contract, and as soon as the dispute resolved, then the smart contract itself execute enforce result of that either arbitration or mediation. But I think there is still could be a dispute because if the resolved decision is wrong or smart contract is wrong, then the people need to challenge that either to court or arbitration. I believe in this case it goes to the court. And then court to decide that this arbitration is wrong, and smart contract is wrong, then they still need to enforce, for instance, specific enforcement under the common laws. But in Korea or Taiwanese, we are civil law countries, and maybe we are also different. And if the court order to nullify the arbitration award in the smart contract, then how the court enforce that nullification of smart contract? I'm just wondering.
Yeah, there are always the limits. So especially when it comes to a cross-border dispute resolution, there's always the limit for the court. But this is not new to the crypto asset. This is simply very normal when there is a cross-border dispute, right? There's always a case where a performance is being made, and then you want to now to rewind the performance, you want to restore to the status quo, but hey, things are beyond your territories. The courts can do nothing about that, or can do very little about that. So I 100% admit that first, there are still a need for the court to get involved in the crypto-related disputes. That's definitely for sure. It's more about the frequency. It's more about the degree. But definitely, you're right that there are always a need. And second of all, there's always a limit for the court enforcement. And that's why people think of smart contract, right? Because smart contract somehow has the potential to resolve those cross-border enforcement issue, to take advantage of the beauty of the distributed ledger technology to handle cross-border enforcement. So that's why people think of smart contract. And so you're right that I believe the courts have their limits there. One advanced way to think of that is some people argue that this is not there yet. What if the court also gets encoded into the smart contract, right? So you have a smart contract that includes the dispute settlement result and then automatically enforce the dispute settlement result. And technologically, you can also include the court decision into your smart contract. So when the court makes the second decision, then the smart contract again execute that. But then that needs a little bit of supplementary device, right? You need to have a separate oracle to connect the court decision into your smart contract. So technologically, it's doable. In practice, there's a long way to go there, right? You want to connect the court decision into the smart contract. That's not technologically impracticable, but in practice, what people need to develop this practice for some while. So, yeah. So
that's brilliant ideas. The code itself built in the smart contract. Wow, that's a great idea. And if that's possible, then do you see there's any necessity to establish a new international treaties about this new kind of era of dispute resolution in crypto world?
To be honest, I don't think that's a new international convention. I don't think that's necessary. I think the existing international dispute convention is flexible enough to contain some blockchain dispute resolution. I have some second thought about the crowdsourced dispute resolution, that's really controversial among the International Arbitration Convention. A lot of paper has discussed how that is incompatible with the New York Convention, for example. But blockchain dispute resolution is not just crowdsourced dispute resolution. There are multiple ways to do that. So back to your question, I don't think there is a need to have an international convention for that. And to be honest, that's not that politically available as well. But I do think people can apply our existing regime in a wiser way, in a more flexible way, and to find a way out for these emerging forms of dispute resolution. Just like 20 years ago, we talk about ODR, we talk about online dispute resolution. We don't really need an online dispute resolution convention to make it work. It could work without a convention. It's more about whether we have a market for that, we have a need for that. So that's my preliminary idea, but definitely I'm not against this idea of having an international convention on that. If you calculate the pros and cons, then probably the cost might be a lot to have this international convention. Maybe there is a less costly way to realize it.
Thank you so much. I'm just wondering, there is a criticism on crowdsourced arbitration because the juror arbitrators are not specialized on this kind of dispute resolution. They might have no background on the law or contract. So the critics criticize that it's not arbitration. Do you think it's still effective under the New York conventions? Before answering your question, please let the audience know about what's crowdsourced arbitration, because not many even dispute resolution lawyers have knowledge about crowdsourced arbitration.
So the crowdsourced arbitration is a special design for resolving online disputes. So the very idea is that people can volunteer, the public on the web can volunteer to become the so-called jurors of this platform. And when the dispute arises, they will send the dispute to the jurors to decide on the merits, on who wins, who loses. So anyone can become a juror to this online dispute and decide on the case on a majority basis. And to ensure that people cast their votes on a good faith, they typically have a special design. That is, if you vote to the minority camp, you will lose some stakes. So, for example, if you want to vote, you probably need to post some collateral into the system. If in the end it turns out that your votes are the minority, then your collateral will be confiscated as a reward to the people who vote for the majority. So that's the general design of this so-called crowdsourced dispute resolution. You could argue that this is pretty democratic. You could argue that this is a majority-based system. You could also argue that this is not necessarily less professional, because who knows, right? People on the web could be more professional, especially when it comes to the crypto disputes, right? It could be more professional than those old-fashioned arbitrator, right? So people can make all the different arguments. But one of the biggest problem of this mechanism is that a juror pays and could lose when they join into the decision, right? So as a juror, there's a tendency for you to guess which side would be the majority one. And you want to vote to that one in order not to lose your property, right? This is not that judicial in my observation. I would argue that if you want to be an arbitrator, if you want to be a third party deciding on the cases on a good faith, you should not get your interest being involved into this dispute. There is a conflict of interest, right? There is an inherent conflict of disputes underlying the juror. So that's the disadvantage that I question, that I challenge this crowdsourced dispute resolution mechanism. And that is why I argued that this cannot be considered as an arbitration, because it's not neutral enough, it's not judicial enough, it involves too much conflict of interest by the jurors. But there are always ways to fix these problems. So What I would argue or try to convince these platforms is you don't really need to design the things to that extreme. You don't really need to have the jurors all from all over places without knowing who they are. You don't necessarily need to have all those jurors stake their capital in or property into this system. You don't really need that. What you need is simply some people there. So I think some platforms start to do things in a more balanced way. Instead of having all the people having access to becoming a juror, they make some selection, right? They have a juror group, or consider that as an expert group, just like an arbitration system having a list of arbitrators, suggested arbitrators. They have a big list of name of experts that they believe qualify for resolving crypto disputes. And they select their arbitrators from this list. They do not require these people to stake in their capital. Instead, they give these people some rewards or some benefits, just like giving arbitrators some rewards. So, yeah, things could be fixed in this way, right? To make these kind of online platform more like an arbitration institution, less like a crowdsourced platform. So things could be fixed. So that's what I try to say. So we don't really need to have those extreme version of crowdsourced dispute resolution mechanism, which takes all the risk of not being classified as arbitration, cannot apply the New York Convention, or even not being classified as a mediation under the Singapore Convention, right? You can design the platform in a more balanced way. And then you may be entitled to be classified as a arbitration, and then everything moves on track. So that's what I would try to urge. We don't really need to go to the extreme. There are more moderate ways to run this crypto dispute resolution platform.
So you think this is not ad hoc arbitration under the New York Convention?
I think this could be a ad hoc arbitration if the problem I mentioned is fixed. Either ad hoc, either institutional, it have all the potential. So my question with the traditional model of crowdsourced dispute resolution is I don't think this is arbitration, because I think too much interest from the arbitrator is involved into the decision-making process, which makes it not judicial, not neutral enough. That's my concern.
I see. So what you're saying is that the arbitrators, in this case, jurors in crowdsourced dispute resolution, they are not independent, not neutral. They have interest, in my view, interest aligned. You said there's a conflict of interest. So they're disqualified as arbitrators. So this decision of the jurors is not subject to New York Convention, and it does not fall into the categories of international arbitration, ad hoc arbitration. But you mentioned the conflict of interest. But when I read this idea, this is interest alignment. And because the system architecture and system architect and the participants agreed that they want to resolve this dispute based on the common sense, based on the interest aligned vote on who get the majority. And the interest is very aligned because they may lose their money, their crypto, on this platform. So when I see that this is great interest alignment to the dispute resolution based on common sense. So I think if this does not fall into the categories of international ad hoc arbitration under the new convention, then there might be a new convention is required.
Right. So I think two things. It could be an interest alignment, but it could also be an interest misalignment. And my point is not to dispute or to argue whether the interest is more aligned or less aligned. My point is there shouldn't be any interest involved by the arbitrator, right? That's what the judicial decision means. The decision maker should not have interest in this dispute. no matter whether that interest is aligned with the dispute or misaligned with the dispute. You have to be an independent third party. So I think you're right that people would try to argue that there is actually an interest alignment. And I would argue that in some cases, it could be a misalignment. For example, what I mentioned, the juror might want to guess which the majority is instead of making their independent decision. So that's why I challenge this mechanism as not judicial enough, because I don't think interest should be aligned. Interest should be involved in that. But to your second question, so do we, if this is not an arbitration, do we need a separate arbitration convention for that or dispute resolution convention for that? Yes or no? Yes, to the extent that if you really want to expand the application of this resolution mechanism, especially having the recognition from the court, from the public sector, then you probably want to negotiate a new rule for that so as to grant some justification to this dispute resolution mechanism and so as to make it recognized by the public sector. Yes, to that aspect. No, to the extent that dispute resolution can also make some adjustment. Like what I said, these problems I identified could be fixed. So you could also make some slight adjustment to make this dispute resolution more like a arbitration or mediation, and then problems are solved, right? So it really depends on, first, whether this dispute resolution wants to collaborate with the public sector. Sometimes they don't. Sometimes they don't see the need. They want to just follow their own way. Then let it be. The second would be if we want to incorporate the system into our existing public regime, then what is the most cost-effective way to do that? To negotiate a big international convention or to just fix the sporadic problems underlying this dispute resolution mechanism? I would argue for the second one, but certainly there could be an option for the first one as well. Oh, sorry, I have to interrupt a little bit because I have another appointment at 10:30, so I probably have to leave at this point. I'm sorry for that.
No, thank you so much. And sorry for Meng Meng. Do you have any question?
It's okay. I'll take another, maybe if he can, like another appointment for like
Sure.
STOs, like things.
Yeah, we can always schedule others.
Thank you so much.
Right.
Thank you so much. Our conversation is very interesting, and I have great time to know about the current system and current movement, and it's very knowledgeable, very insightful, and thank you so much.
No problem at all. Thank you.
Yeah, thank you. See you again.
See you. Thank you.